read it. I understand that a copy of it was also provided to Mr. King. And I'm prepared to hear.
The copy that was faxed to you, I'm not sure if it had the exhibit.
No, it did not.
May I approach the bench? I have the hard copy.
Absolutely. Actually, Officer Sewing, Officer.
Chris.
Yes. That has it there. I apologize, Judge. I gave hard copy to the prosecutor also, Judge.
Did you see this complaint, Mr. King, that was filed by the state in this matter?
Later, about an hour ago, this is provided.
There are additional charges that were filed, civil service charges that were filed against your client as a result of this matter.
The day after he was convicted, the town of Morristown suspended him without pay on the basis of local ordinances. And that's what you have there. That's being appealed also. But I attach that because that's the one document that I have that identifies up in the top box that his permanent civil service title is as the chief housing inspector.
I understand what you're saying.
Yeah, I mean,
and I have read your brief, and I understand that that was just, let's say, an adjunct is the way you describe it pretty much.
And they've also, my understanding is about 2 months ago, the town reorganized and they consolidated a number of departments, and that department no longer exists, and his position as the director of the Department of Human Resources no longer exists. So his job has always been as the chief housing code enforcement officer. And with respect to the argument, I thought that I would submit it in writing because we can read faster than I can talk.
You did such a fine job.
So I don't think that I have to go through all of it.
No, you did, and I read it, and I read it, and I mean, certainly Section 1 doesn't apply. It's under Section 2 that we're dealing with. A1 doesn't apply. A2 is the portion of the statute. 2C51(2)(A)(2) is convicted of an offense involving or touching such office, position, or employment. And your position, I will tell you what your position is. I'll allow you to elaborate on your position.
Well, Judge, the statute and the case law, the uniform that when you're talking about public or touching upon public employment, you have to use the public position to commit the offense. And that's where, for example, to delineate the difference between, say, the mayor of Jersey City.
The McMahon case.
I
read what you put there.
And I think that the paradigm is the Steele case where the business administrator of the Board of Ed of Irvington was convicted of official misconduct when he used his office to shake down contractors. That's the paradigm of touching or involving. Where in this case we have, and I can go on and on.
I know, I read them, and it was very good. I mean, it was enlightening, the whole thing.
And also, just one thing I might add.
I'm going to ask Mr. Right, I apologize.
That's okay, Judge. There is an addition, I didn't want to clutter this up, but there is an additional statute that deals with pension forfeiture, which I think has some relevance. That's not involved in this case.
That I am absolutely not involved in,
right.
And I am not seeking the forfeiture of the pension whatsoever.
However, one thing that's enlightening there is they use the same language as in Title 43 of the statute. And that statute, they delineate the specific offenses which will result in a pension forfeiture, including NJSA 2C:13-5, criminal coercion. These are the lists. It's included. And I think it just goes to show that you have to use the public position to commit the offense. Just the fact that, say, a police officer who has a duty to enforce the law, if he gets in a DWI and kills somebody, that's one of the cases I submitted. One could argue, well, that has relevance to his position as a police officer. The appellate division said, no, it's not. That's private conduct that he's going to be criminally charged for. In that case, there was a criminal conviction of assault and brought on. But
and I did read your decision.
So,
your brief on that. Okay, is there anything else?
okay.
And again, I want to make it clear that as far as this court is concerned, we're not looking to have any forfeiture or suspension whatsoever.
Right.
That is not my intention. Applying this particular statute as to whether it applies or not. But I'll hear you, Mr.
Well, if I could just finish.
Go ahead. Sorry.
On the basis of what the statute said and all the cases, and I've read every case that's cited by statute, I don't perceive how the court could possibly forfeit his public position under these circumstances, where we have private conduct. One could say, yes, maybe, he's the animal control officer. He's really not. His job is, what does it have to do with his job as the chief housing code enforcement officer? This is private conduct. He didn't use his job to commit an offense.
And I understand the distinction you're making. I'm going to give you an opportunity to reply to,
sure,
which is something I normally wouldn't do. I'm going to give you an opportunity to reply to Mr. King. So,
sure.
Judge, I would argue that, in fact, it does touch upon his office. At the time that this occurred, he was in charge of the department that oversaw, or actually the department. He was the department head, which under him was the animal control officer and the health officer. These are the people that are the ones who have to enforce, as we heard from the trial, they're the ones that ensure that the dog is licensed. We heard the importance of why an animal is licensed. He knew that the dog should have been licensed. He tried to cover that in the trial. He provided documents for it to be a license, which really was just a rabies certificate. It wasn't a license. That was later corrected. In addition, he called one of his employees, which he had supervision and control over, to come and try to pawn off the dog or to cover up what had occurred. He could have easily have sent the dog to a vet, could easily have sent it to a shelter, gotten some type of help for the dog, but yet he called the person under him who he thought he could control to take this dog to resolve the problem. So I think that he did use his office to cover or to continue to perform the cruelty of this animal. In addition, as I stated, he should have known with regard to the licensing. That was not done. That's another component of this. And also he should have known, as the person who people come to when there are problems with regard to dogs, that this behavior should not have happened. He should have known better. And I believe that he did use his office to try to cover up this crime.
Mrs. Moylen, thank you, Mr. Moylen. Let me just, as far as I'm concerned, animal control was under his auspices, okay? And that was part, whether he was directly involved or someone else was, that was part of his overall office, under the umbrella of his office.
One thing, you might be able to forfeit him as the director of the department. You can't forfeit him as the chief code enforcement officer.
That's an interesting issue.
I mean, aside from the fact that the argument...
But okay, let me just take it from that.
Okay, sure.
There's two issues he's raised. One is the licensing issue, and two is the so-called employee cover, or where he calls the employee who's the head of the animal control department and tells her, let's keep this between ourselves, and let's, and then goes on to office. Now, those two issues I'd like you to address.
It was a very nice argument, Judge, but they're not completely irrelevant, and it's not the law. First, what was he convicted of? He was convicted of animal cruelty. He wasn't convicted of coercion. He wasn't convicted of
Let me interrupt you right there. Animal cruelty, doesn't that touch upon his office? Isn't that part and parcel of what the Animal Control Department monitors?
Doesn't driving while intoxicated and killing a person with your automobile reflect upon a police officer's duties?
I don't know that that's a good
Judge,
statement.
you have to use your, I don't see how one, unless, I can't conceive of any circumstances under which you could use your official duty to perpetrate animal cruelty. What he was convicted of, we have to be careful.
I understand what you're saying.
Okay, he was convicted of animal cruelty. He wasn't convicted of coercion, he wasn't convicted of official misconduct, he wasn't convicted of, and he wasn't charged with any of those. He wasn't charged with trying to cover up something. So let's get this straight. He was convicted of animal cruelty, a disorderly person's offense, which you would impose a fine of $500 and some other things. No jail time, no loss of license. Okay? Now, is that sufficient to forfeit a job of 35 years as a chief housing code enforcement officer? Now, the prosecutor said, well, you know, he should have known this is within his bailiwick. It's all very well and good. That's not the law. The law is, and again, the argument of the state is just what the Supreme Court said. The contention is that a criminal act must be considered to touch an office if the conviction of criminality occurs during the occupancy of public office by the felon, and if the underlying crime is such as to reflect so adversely on the character and integrity of the actor that no reasonable person would be confident of his ever wielding government power. The court says that argument is flawed in several respects, and it's not the law. You have to use the official position to perpetrate the offense. Because it's really, when you think about it, it's really draconian, the penalty. You're forfeiting your job on a disorderly person's offense. Okay? So, it has to meet certain very, very specific standards. How did he use his job as the chief code enforcement officer to commit animal cruelty? Under the case law, I just can't see how that, if the argument is, does it reflect badly on his, yes, one can argue that. Is it relevant to say his duties? Yes. All those types of arguments.
But the fact that he used his office, potentially, when he called the animal control officer and attempted to use that office to cover up the situation.
He wasn't convicted of that, Judge. He wasn't accused of that.
Wait a minute. It's factual, but it's factual.
He wasn't accused of that. By that time, the offense had already occurred. The animal cruelty had all, I mean, assuming the truth of everything that was in, I have to, so for this.
Well, that's a good point. How do we respond to that?
Well, Judge, I respond using the argument that counsel made with regard to the teacher. When a teacher comes in and shoplifts, she's not, her job as a teacher is not impacted. She's not using her job as the teacher to shoplift, but yet you can forfeit because of the stealing is not something right. It goes to her. Same thing here. Here he is the person who oversees. He's the one that makes sure, or is required to make sure that the animals in Morristown are treated properly. He's the one that has the people under him who ensure that these animals are licensed, etc. And yet, he's done animal. He's been found guilty of animal cruelty. It does. It's equally, him being found guilty of animal cruelty is no different than a teacher who shoplifts and is found guilty of shoplifting. I understand counsel is snickering, but there's no difference.
Judge, that's not the law. The law is the reason why the teacher is forfeited because of another portion of the statute that says if the offense involves dishonesty, you forfeit your job. That's why the teacher forfeits on a shoplifting. That has no relevance whatsoever to this. It's an animal cruelty charge. That doesn't involve dishonesty. So counsel, it's all very well and good. There's not one case he cited or one part of the statute that he cited to the court. We have to look at what was he charged with, what was he convicted of, and what was his duty. Now, all these arguments, yes, one can make them. Unfortunately, they happen not to be the law. The law is, under all these cases I cited, and that's why I went to great extent to cite them all and to explain them, is that where the public office is used to commit the offense is forfeited. The fact that it may reflect badly upon you in your public office is of no relevance. The shoplifting case doesn't apply, that's another part of the statute. You forfeit...
Let's say I agree with you. Let's say I agree with you.
Yes, sir.
That applies to everyone. Let's forget that part. The courts, the Hupka case talks about must examine the relationship between the exact offense committed and the particular position held by the individual in order to reach a conclusion that the commission of the offense had some direct connection to the office held. That's you cited State versus Hupka in this particular case.
Well, in that case, I mean, the Supreme Court just said that the conviction of the sheriff's officer of a fourth-degree criminal sexual contact, while not on duty and not in his uniform, did not involve or touch upon his public employment. Certainly, it would reflect badly upon it. Certainly, he has a duty to enforce the law, and he violated the law. But the court said the distinction is, did he use, and you look at that and say, in comparison with the other case, in State versus Williams, where the police officer flashed his badge and fired his service weapon during a bout of road rage as a private citizen. There, he used his position as a police officer in flashing his police badge and firing his service revolver as a private citizen. That's the distinction between the two police officers, State versus Williams versus In re Hess. And in re Hess, the police officer was intoxicated, resulting in death, criminally prosecuted for second-degree assault by auto. Oh, I'm sorry, Judge, that's not the police case. There's another police case. Well, the two police cases, there's one where the police officer used his job to illegally access the state police computer system to check on the employment for a private employer. So he used his position as a police officer to commit an offense. In State versus Steele, the business administrator used his job as business administrator of the Board of Ed to shake down public contractors. In Moore, the corrections officer harassed his superior while off duty in retaliation for a job-related disciplinary charge. So in each case, they used the public position to commit the offense.
All right, what about the licensing issue? Deal with that. He
Judge-
doesn't license his dog.
Judge, what was he convicted of? He was convicted of animal cruelty.
Well, no, he was convicted of also the licensing issue. I mean, you know,
Judge,
that
it was a $10 fine.
Well,
for
whatever.
dog
I
license.
mean, deal with that. I mean,
Okay.
deal with the issue.
Okay, he didn't use his job to not license the dog. How could he use his job to not license the dog? How could he use his job to commit animal cruelty? It's not like the police officer who flashes his badge and fires his gun in a fit of road rage. There he's using his job to commit the offense. Mr. Steele used his job to shake down contractors. By the time everything was involved, the offense had been committed. It was entirely private conduct.
Okay. I understand.
So
And I understand your word.
If I could
Go ahead.
say something. He did use his job. He used his job as a person 35 years in the community. He thought he was above the law. He thought he did not have to license his dog. He knew. If anyone knew, it was him, because that was one of his daily operations, is to oversee and ensure that every other resident in Morristown, his animals were licensed. But he felt he didn't have to, so he was using his job, his position to cover. He also used his position again to cover when he called his employee there to try to pawn off the animal. So he did, in fact use his job. Also, Judge, with regard to the cruelty, I think the cruelty of the animals is just not a cruelty, but it's also a dishonest. It talks about a person's behavior, about him not providing shelter, food, water to this animal, and then when an official, which is the animal control officer, comes to him, he lies. He was using his position, and that's a dishonesty. That's all part and parcel of the cruelty and what he was found guilty of.
But he wasn't convicted of that.
But, you know, there's also an issue of due process here.
Yeah, I mean, wait.
I mean, I'm hating a moving target, I'm not making an
I
argument,
agree
he
with
comes
that.
up with a new one.
No, I agree. Well, he's making his argument.
I understand, but I mean,
I agree with you.
I have a
understand, but
man.
there was no conviction.
Yeah, but I mean, I have a man who's
The
convicted.
licensing issue bothers me, and the fact that he does call someone, that's like some public works officer calling an employee of his and saying, hey, listen, go shovel my driveway, or go plow my driveway with the town truck, or something
What
like
he was
that.
charged with.
But what he did, well, no, what he did was, he didn't license his dog.
Go ahead, huh?
You know, I mean, and counsel, come on, we're having a discussion.
I understand, Judge. I'm a
I
little bit
mean,
frustrated.
I understand your frustration, but we're having a discussion.
I understand, Judge.
Please.
I understand, yes.
You know, we're talking about someone now not doing something that his department is responsible for. He doesn't license his dog. All right, that's one argument. The other argument, and these are the two that bother me, is the fact that he does make that infamous phone call to I forget her name, the head of the animal control department, and at that particular point says, look, you know, I don't want anybody to know about this. We got to get this dog somewhere. And does that not touch on his office?
Judge, the law is he has to use his office.
I don't know. It has to touch on his office. You go as far as saying use. I don't know.
The opinion,
I read those.
the Supreme Court case, if I just might,
Go
just so
ahead.
the record's clear.
Go ahead,
The
please.
Supreme Court case, there's two classes of felons in the McCann case at page, it's 167 NJ at page 335.
That's right.
Those who commit dishonest acts, not
We're not there, and I agree with you.
and those who use their office to do so. He was convicted of animal cruelty. He was not convicted of trying to coerce the animal control officer. He was-
I've heard enough. Okay, I've heard enough. Counsel approach, off the record.
I understand.
Licensing, that probably. That's what I'm saying. Maybe it's not even a deep case. I'm going to give this one. He's got this. He's got it. He's convicted. He's been. Well, you know what? I got to try to think. I got to tell you, it was the furthest thing. And his son was still. Well, you did, no, I just want you to try to make some ideas. There's no question about it. I really looked at this thing. I'll give you this one. All right. Put back on the record. After careful consideration and reading the briefs and hearing the arguments of counsel in this particular matter, I am not going to forfeit his position under the statute. I understand there are complaints, civil service complaints, in which they seek to dismiss his job. I do believe that I felt about this whole case, but whether or not it touches on his office is questionable, and I'm somewhat doubtful that it may or may not, except this may apply to the licensing issue, which was a local ordinance. So on that basis, that I feel that it may or may not touch on his office. I think counsel may be right that he has to use his office to accomplish, for it to be found to be a touching on the position, and I agree with that, and so therefore I will not, under 2C51(2), forfeit statute, forfeit his position, and the convictions will lie. You have 20 days, of course, counsel, from today to file your appeal on this matter. Thank you very much.
Thank you, Your Honor. Judge, just for purposes of counting time, the 20 days will count for the conviction also?
Yes, for everything. Today's the final day.
Today's the final day, so we start counting as of today.
The clock starts on the 20 days, not from the date of the conviction.
Okay, very good.
Because we have this additional motion.
All right.
So you have 20 days from today's date to file that appeal.
Okay, thank you very much, Judge.
Thank you, counsel.